Good afternoon. My name is Eliana Alcivar, and I am a partner in the Technology and Data Privacy Practice Group here at Bayer Crosby McNemis. Thank you for joining me today, particularly in the middle of this busy holiday season. Today, I'll be speaking with you about the California Consumer Privacy Act. I'll be touching on some recent developments, and I will attempt to arm you with some tips to prepare for compliance. My presentation today is split into three general parts. In part one, I provide you with an overview of the California Consumer Privacy Act. In part two, we look at a set of proposed regulations recently issued by the California Attorney General to help clarify and implement various aspects of the law. And then finally, in part three, I suggest to you some practical ideas on what you can do to go about as you implement your plans for compliance. The law goes into effect on January 1st, so the deadline for compliance is right around the bend. First, we turn to an overview of the CCPA. This law is massive in its scope, so let's get started. The CCPA was enacted on June 28, 2018. It establishes a comprehensive consumer privacy framework, the first of its kind in the United States. It creates new rights for California residents with respect to the collection and use of their personal information, and it imposes corresponding obligations on covered businesses. It will impact companies of all sizes around the country and indeed throughout the world. Some of the new rights created under the CCPA are unprecedented in the landscape of United States privacy law. The California AG alone is empowered by the CCPA to bring enforcement actions. The period for bringing enforcement actions won't begin until July 1st, 2020. However, delayed enforcement does not mean delayed compliance obligations. It's important that businesses have a plan to begin complying effective January 1st, because if you become one of the unlucky targets of an enforcement action, the AG is empowered to examine your conduct going all the way back to the start of January. Next, we spend a few minutes taking a high-level look at the categories of new rights and corresponding obligations being created under the CCPA. These rights and obligations can be practically divided into four categories. First is the right to know. The CCPA gives consumers a right to be informed about a business's practices regarding how a business collects, uses, discloses, and sells the consumer's personal information. If this sounds like a privacy policy, you're on the right track, and indeed, one of the obligations that businesses have under the CCPA is to post a privacy policy that complies with the CCPA's specific form and content requirements. But the CCPA goes further, and it's adamant in its requirement that a notice be provided to consumers at or prior to the point of collection. And there's some very specific pieces of information that must be included in this notice, as you'll see, especially when we turn to our discussion on the recent proposed regulations. But there's more. In addition to a general privacy policy and these general notices, the CCPA gives consumers a right to ask a business to provide information about the personal information that the business has collected from that consumer. This includes the right to request general information, but it's still specific to that consumer. And last but not least, the consumer has a right to receive a copy of the personal information that the business has collected about that consumer. When responding to all these types of requests, a business need only provide information to the consumer pertaining to the 12-month period immediately preceding the consumer's request. So, if a company has maintained a relationship with the consumer for 10 years, doesn't matter, the CCPA only requires that the business tell the consumer about what it's done with the consumer's personal information in the last year. Next up, the right to opt out. Consumers have a right to direct a business not to sell their personal information. Key obligations here are that the business must provide a compliant method to the consumer to opt out of the sale of their personal information. And then, of course, the business must stop selling personal information upon receipt of an opt-out request. Third is the right to deletion. The CCPA provides to California residents the right to contact a business that holds their personal information and then ask them to delete it. And if the business cannot find an exception under the law, the business must delete the information. There are a great many exceptions available under the law to this requirement, and you should definitely plan to get to know these exceptions if you are subject to this law. A business that receives from a consumer a request to delete personal information must also direct its service providers to delete any personal information that the service providers hold about the consumer. Final category of rights, a business must refrain from discriminating against consumers who exercise their CCPA rights. So businesses cannot charge different prices or rates to consumers who exercise their rights under the CCPA. In fact, a business is not even allowed to suggest that the consumer will be discriminated against. There are a couple exceptions to this general prohibition against discrimination. The first is the reasonable relationship exception. So a business can impose a price level or quality difference if any of those actions are reasonably or directly related to the value of the consumer's personal information. So this exception would capture things like a business offering a service for free to some consumers who agree to the sale of their personal information, and then the business turning around and offering the same service for a fee to consumers who opt out of the sale of their personal information. The key here is that the fee charged to those who opt out must be reasonably related to the value of the personal information at issue. Second is the financial incentives exception. So here, a business can offer financial incentives for the collection, sale, or non-deletion of personal information, but only if these incentives are not unjust, unreasonable, coercive, or usurious in nature. This exception would capture things like loyalty programs. The regulations go on to provide a lot of detail on notices that must be provided to consumers related to these exceptions, including that the business must explain the material terms of the financial incentive or price or service difference, and the business must also explain why the financial incentive or price or service difference is permitted, including the business must provide a good faith estimate of the value of the consumer's data and also a description of the method that the business used to calculate the value of the consumer's data. These rules are going to force businesses to show their math and demonstrate to consumers how they arrived at the dollar amounts related to these financial incentive and reasonable relationship programs. Next, let's spend a little time looking at some of the important terms used by the CCPA. Probably goes without saying, but these 4 terms represent far from a complete list of definitions found in the CCPA. But in the interest of time, I picked out a select few to focus on today. First, business. Business is a term used by the CCPA to define who is mainly subject to the CCPA's compliance obligations. A business is defined to mean everything you see in the column to the left and at least one of the things you see in the column to the right. So all businesses must be a for-profit entity that collects personal information or has personal information collected on its behalf. The business must do business in California, and it alone or jointly with others determines the purposes and means of the processing of the personal information. And then, assuming the business qualifies under all of those criteria, it must also qualify with one of the criteria listed on the column to the right. By the way, the CCPA also applies to parents and subsidiaries that share common branding with a covered business. Next is consumers. Who are consumers? Consumers are those who are protected under the CCPA. Consumers are defined in the statute as residents of California. To help us understand what is meant by resident, The CCPA points to a separate California regulation that defines residence for the purpose of the requirement to pay taxes in California. An important question you'll need to ask yourself is whether you can, from a practical standpoint, distinguish the personal information of California residents in your database from the personal information of non-California residents in your database. If you don't collect full address or residency information from consumers, how will you go about deciding what information in your database is associated with California consumers? This may require some creative thinking and resort to technology solutions by businesses. Businesses that are subject to the requirements of the GDPR have faced similar challenges in implementing methods for recognizing when data is coming from a European or other person protected under the GDPR. Some businesses may determine that they simply cannot make the distinction with confidence, and they may opt to go ahead and treat all consumers the same, extending to all consumers all protections under the CCPA, regardless of the consumer's residency. For example, Microsoft recently went on record to announce that they would be extending the protections of the CCPA to everyone. While this certainly is a move that positions Microsoft as a privacy-friendly organization, one also has to wonder if part of the motivation behind this move was a desire by Microsoft to avoid that whole, having to separate California consumer personal information from everyone else's thing. So next, I wanted to talk about personal information and sale. So the definition of personal information is extremely broad and could capture about anything you can imagine. So what is not personal information under the CCPA? The CCPA does create a few exclusions. Here we have information made publicly available from federal, state, or local government records. That's not considered personal information. Also completely excluded is de-identified consumer information or aggregate consumer information. A word to the wise, if you're a business hoping to take advantage of these exceptions, the CCPA contains some very nitpicky requirements on what it means for data to be de-identified or aggregated. So make sure you familiarize yourself with these requirements. The definition of sale is also very broad and, importantly, can include non-cash transactions. The concept of sale is important because it triggers obligations such as the obligation to provide consumers an opportunity to opt out with sale of their personal information. The CCPA does carve out some exceptions from the concept of a sale. One of these is transfers of personal information to a service provider if necessary for a business purpose. Let's pause here because service provider is a defined term under the CCPA, and these are entities of great significance under the law. There are some special requirements that apply before an entity may be considered a service provider, including having some special contract language in place. While the full scope of obligations under the CCPA that apply directly to service providers is a bit unclear from a plain text reading of the CCPA, there are some requirements that apply quite directly to service providers in the text of the recent proposed regulations by the Attorney General. If you're an entity that qualifies as a service provider, you need to figure out what your obligations are because the CCPA permits the Attorney General to pursue enforcement actions against service providers for violations of their obligations under the CCPA, whatever those obligations may be. Also relevant to the definition of personal information, I wanted to touch on an important exclusion that went into effect by way of recent amendment to the CCPA. This exemption is for certain information held by employers, such as employee and other personnel information, emergency contact information, and personal information concerning employees' beneficiaries. However, the exemption applies only to the extent that the employer is using the information for employment purposes. So, if an employer takes an employee's information collected in connection with employment and then tries to sell the information, that would likely fall outside the scope of this exemption. The exemption is limited in the following additional ways. It is only in effect until January 1st, 2021. The employer must still provide required notices to its personnel at or prior to the point of collection of personal information. And there is no exemption available for this category of information from the private right of action available to consumers for data breaches under the CCPA. I'll be telling you a little more about that private right of action momentarily, but for the time being, just be aware that employees can sue employers under this private right of action available under the CCPA in the case of data breaches. I won't be covering it here, but just so you're aware, there was another key exemption that recently was signed into law, applying to certain B2B information. That exemption also expires on January 1st, 2021. Now we turn to an examination of the enforcement vehicles available under the law to respond to violations of the CCPA. These enforcement vehicles arrive in two varieties. First up, enforcement actions by the Attorney General. The California Attorney General alone is authorized to enforce violations of the CCPA by pursuing civil enforcement actions and seeking administrative penalties. Actions can be brought against covered businesses, service providers, and other persons found in violation of the CCPA. The penalties available are not premised on the AG having to prove actual damages. Rather, these are statutory penalties calculated on a per violation basis. The amount of the penalty varies depending on whether or not the violation is intentional. There's also no cap on the amount of damages that the AG may collect from a business. Before initiating an action, the Attorney General must give the business, service provider, or other person notice of the alleged violation and at least 30 days to cure the violation. It is only if the business thereafter does not or cannot cure the violation within the 30-day period that the AG can proceed to seek civil penalties. Second, are private rights of action that ordinary consumers are entitled to bring under the CCPA. However, the private right of action is not for just any violation of the CCPA, but rather it may be brought by a consumer only for certain unauthorized access, theft, or disclosure of their personal information. In other words, data breaches. Additional requirements that apply are that the personal information must have been in non-encrypted or non-redacted form, and that the data breach must have resulted from the business's violation of the duty to implement and maintain reasonable security procedures and practices under the California data breach law. The private right of action also uses a limited definition of personal information. While this definition was recently amended and expanded, it is still narrower than the standard definition of personal information found in the CCPA. Consumers can seek an injunction. They can also seek statutory damages from anywhere between $100 to $750. They can also seek actual damages. They can also seek any other relief that a court deems proper. One can imagine that this could include attorney's fees and punitive damages. As for those statutory damages, those are only available if, before filing a lawsuit, the consumer provides the business with written notice identifying the specific violations and a 30-day period to cure. And the business thereafter does not or cannot cure the violation and does not provide the consumer with an express written statement that the business has cured the violation and no further violation shall occur. For this reason, it's going to be critical that covered businesses keep on the lookout for these consumer notices asserting a violation of this data breach provision. Businesses should be prepared to jump on the matter and respond promptly. Final thing to note, because the impact of a lawsuit of this type is going to be far more damaging if brought in the form of a class action, covered businesses should consider implementing, wherever possible, to the extent they've not already, mandatory arbitration and class action waivers in all their contracts with all protected consumers. There is some language in the CCPA suggesting these would not be enforceable under the CCPA, but there is also reason to believe that federal law would preempt the language in the CCPA to the extent it would prevent the enforcement of mandatory arbitration and class action waivers. So don't let the language in the CCPA prevent you from trying to set these protections in place. The worst that could happen is that later on they are deemed unenforceable. On to part 2, the California Attorney General's proposed regulations. On December 10, 2019, the California Attorney General published proposed regulations under the CCPA, which are intended to shed light on how covered businesses must go about implementing the law's requirements into their day-to-day business operations. They are, in the words of the AG, to provide practical guidance to consumers and businesses subject to the law. The proposed regulations are not yet final or officially in force. The public comment period for these regulations ended only just recently, on December 6th. Per the CCPA, the AG's final regulations must be published on or before July 1st, 2020, which means that the final regulations may not technically go into effect for up to 6 entire months after the CCPA effective date of January 1st. Still, businesses should consider preparing their plans for compliance based on the CCPA as supplemented, where reasonable, by the text of the proposed regulations, as these combined sources provide the best and most up-to-date sources of information anywhere on how the AG intends to interpret and enforce the CCPA. The proposed regulations are split into 5 articles. Article 1 contains some new definitions, which we won't spend time on here, but which you'll definitely want to check out. Article 2 is roughly focused on the various notices that covered businesses must provide to consumers. In the regulations, you'll find many detailed form as well as content requirements related to the various notice requirements. Concerning the notice required to be provided by businesses at or prior to the time of collection, you'll find certain form requirements in the regulations, such as, and these are just some examples, a requirement that the notice must be easily understandable, and it specifically says to avoid technical or legal jargon. The notice must be visible where consumers will see it before collection. It must be available in all languages in which the business in its ordinary course provides information to consumers. So if you regularly provide sale ads in English and in Spanish, make sure that your notices are provided to consumers in English and in Spanish. And also, the notice must be accessible to consumers with disabilities. If you've never had to think about making your website accessible to consumers with disabilities, and you are covered by this law, consider sorting through the various resources provided by the federal government, which are relevant to compliance with the Americans with Disabilities Act, which include materials for making websites ADA compliant. In the proposed regulations, you'll see that many of these form requirements that we just went over apply to many of the other forms of notice required under the CCPA. I won't mention them again, but that doesn't mean that they don't apply to the other forms of notice we'll be discussing. Also in the regulations, we encounter a summary of the detailed content requirements that must be included in this notice. This would include categories of information to be collected, business or commercial purpose for which the information will be collected, a do not collect my personal information link, and a link to the business's privacy policy. Here, it's useful to highlight that the regulations provide tons and tons of guidance for companies that collect information from consumers in the real world. Even if you are a business that only collects personal information from consumers offline in the physical world, you still do have to comply with the CCPA, and the regulations go to great lengths to make this clear. So, for example, the regulations that cover this obligation to provide a notice to consumer at or prior to the point of collection of personal information contains guidance for how businesses that collect information from consumers offline are to provide this required notice. This could include, for example, posting prominent signage. In the interest of time, I will not be further detailing any of the rules found in the regulations that apply to the offline collection of personal information. But if this is you, please be sure to familiarize yourself with these rules, as they will have a direct impact on your compliance efforts. On the slide, you see a couple interesting provisions found amongst the rules concerning the notice required to be provided at or prior to the time of collection. These provisions reinforce the importance of ensuring that you have the appropriate notices in place before you go out and collect personal information from consumers. First, a business shall not collect categories of personal information other than those disclosed in the notice at collection. The lesson to be learned here: ensure your notices are accurate and kept up to date to reflect your actual business practices, or else that becomes a violation of the CCPA. Similarly, if a business does not give the notice at collection to the consumer at or before the collection of their personal information, the regulations state that the business shall not collect personal information from the consumer, period. A key new exception is created under the regulations for businesses that do not collect personal information directly from consumers. These businesses need not provide the notice at or prior to the point of collection, but here's the catch: before the business that collected the information may sell the information, the business must either notify the consumer directly and provide to the consumer an opportunity to opt out of the sale, or the business can go to the source of the personal information and get that source to provide certain assurances in writing. And then the business must then hold on to those signed assurances for a certain amount of time and make them available for examination by the consumer. Next, we look at what the regulations have to say on providing to consumers a notice of their right to opt out of the sale of their personal information. The regulations clarify that businesses need not comply with this requirement if they do not, in fact, sell consumers' personal information. However, businesses that sell personal information must go on record and affirmatively state in their privacy policies that the business does not and will not sell personal information. The regulations tell us that a link to the information on how consumers may exercise their right to opt out should be placed on the business's website homepage. A startling new penalty of sorts found in the regulations, and nowhere in the CCPA, by the way, is a provision that personal information collected in the absence of an opt-out notice is deemed to have been submitted subject to a valid opt-out request. So if you intend to sell personal information, please make sure you provide to consumers notice and an opportunity to opt out, or else risk suffering this consequence, in addition to just generally being in violation of the CCPA. Finally, in Article 2 of the proposed regulations, it should come as no surprise that the AG spends a good amount of time on the requirements applying to privacy policies. Yes, the proposed regulations reinforce that you must have a privacy policy, and yes, there are some very detailed content requirements on what must be included. The regulations further provide that you must have a conspicuous link to your privacy policy on your website homepage or on the download or landing page in the case of a mobile app. Oh, and also, by the way, make sure your link makes use of the word privacy. This may seem obvious, but on occasion, I do see businesses that post a link to their privacy policy which is labeled terms or legal or the like. Lastly, I wanted to highlight the regulations requirement that the privacy policy must feature a last updated date. I thought this was interesting, since one of the requirements applying to privacy policies under the statutory text of the CCPA is that businesses must update their privacy policy at least once a year. Just be aware that an argument can be made that a policy that's sitting out there with a last updated date that is years in the past could signal to the Attorney General that you have not been complying with your obligation to update your policy annually. Let's pause here to talk about what the law has to say on verifying the identity of consumers. CCPA and the proposed regulations reflect well-founded concern over the risk that con artists may attempt to use a CCPA as a means to obtain unauthorized access to consumer personal information or to maliciously destroy consumers' information, in each case by submitting requests while pretending to be the consumers. To help guard against this risk, the CCPA says that businesses are required to comply only with verified requests to know and requests to delete. And the regulations offer more detail in this vein, providing that covered businesses must establish, document, and comply with a reasonable method for verifying that the person making a request to know or a request to delete is in fact the consumer about whom the business has collected information. The regulations set out a flexible standard for a verification method. In choosing a method, businesses should consider the type, sensitivity, and value of the personal information being collected and maintained about the consumer. Sensitive or valuable personal information shall warrant a more stringent verification process. FYI, some information is considered presumptively sensitive under the regulations. The proposed regulations provide that businesses are permitted to use third-party verification services as long as those services comply with all applicable requirements under the CCPA. The proposed regulations also contain suggestions for how businesses can verify the identity of consumers who hold password-protected accounts with the business. These businesses may find these suggestions to be the most cost-effective way to comply with the consumer identity verification requirements of the CCPA. However, the regulations prohibit a business from forcing a consumer to create an account with the business simply for complying with this verification requirement. Of course, the regulations contain a lot more detail on verifying consumers' identity. So if you're subject to this requirement, I definitely encourage you to take a look at all of those. Now we turn to examine what the regulations have to offer on a business's obligation to provide to consumers a vehicle for exercising their right to know and their right to delete. These requirements are detailed in Article 3 of the proposed regulations. For requests to know, covered businesses must provide consumers with 2 or more methods for submitting such requests. Always required is a toll-free number. And if a business operates a website, also always required is an interactive web form. Other acceptable options can include a designated email address, an in-person form, or a mailed form. On requests to delete, covered businesses must also provide consumers with at least 2 methods for submitting requests to delete personal information that the business holds about the consumer. Interestingly, the CCPA is silent on the methods which businesses must provide to a consumer to exercise their rights to delete. So the regulations step in to fill this void. Always required is at least 1 method that reflects the manner in which the business primarily interacts with the consumer. Other acceptable options include a toll-free number, email address, a link or form available through the website, an in-person form, or a snail-mailed form. To guard against consumers accidentally submitting requests to delete their information, the proposed regulations require that a business must provide a 2-step process for deletion when a consumer is submitting an online request to delete. In step 1, the consumer submits their request to delete. In step 2, they separately confirm that they want their personal information deleted. On to methods for submitting opt-out requests. Businesses must provide at least 2 designated methods for submitting requests to opt out. The regulations also tell us that businesses must provide, at a minimum, an interactive form on the business's website, which is accessible via a clear and conspicuous link titled, "Do not sell my personal information" or "Do not sell my info." These must be included on the business's website or mobile application. An interesting provision found in the opt-out regulations is a requirement that a business must honor as an opt-out request user-enabled privacy controls, such as a browser plugin, privacy setting, or other mechanism that communicates or signals the consumer's choice to opt out of the sale of personal information. The most common example of the type of technology the Attorney General may have had in mind here is where you can set up your browser to send a do not track signal to the servers of a business whose website you are browsing. This regulation seems to require businesses to treat do not track signals as opt-out requests. Yet this requirement is found nowhere in the text of the CCPA. As a result, businesses have voiced concern in response to this regulation. But I wanted to make you aware of it, as it does open up a whole new area that businesses up until now may not have ever needed to pay attention to. The proposed regulations add clarity and some new requirements concerning the timelines for responding to consumers' requests under the CCPA. First, the regulations add a brand new initial response requirement, which is not in the text of the CCPA. Within 10 days of receipt of a consumer's request to know or request to delete, covered businesses must provide an initial response to the consumer, which basically confirms to the consumer that the business is in receipt of the request. The business then has 45 days from its receipt of the consumer's request, that is, not from the end of the 10-day period, from the date of the consumer's request, to comply with or deny and then formally respond to the consumer. But a business may invoke an additional 45-day extension if necessary, so long as the business contacts the consumer to explain the reason for the delay. The clock begins to tick when the business receives the consumer's request. No extra time is allowed for the business to verify the identity of the consumer. So just make sure that the verification method that you select is relatively speedy. Also to note, there is actually a provision in the CCPA which appears to allow businesses to have an additional 90-day extension after the initial period for compliance passes. It's unclear to me how that's supposed to work in combination with the timelines detailed in the regulations, which say you have 45 days plus 45 days maximum, but there you have it. So now let's take a look at what the regulations have to say on a business's obligation to respond to a consumer's request to know about the personal information that the business has collected from the consumer and how they've used it, and a consumer's request to ask for a copy of their personal information that the business has about them. A response to a consumer's right to know request is always mandatory, even if it's only to inform the consumer that the request has been denied and the reasons why. The regulations contain further detail on the required content of both approvals and denials in response to consumer requests to know. I won't cover every detail here, but please make sure to check out these requirements if you are subject to this law. I do want to call out one specific issue. Be aware that the regulations contain a categorical prohibition on providing certain very sensitive information to consumers. Generally, disclosure is prohibited if providing the information would create a substantial, articulable, and unreasonable risk to the security of either the consumer's information or to the business itself. But in addition to this general prohibition, the regulations go beyond the text of the CCPA in specifically prohibiting the disclosure of certain very sensitive information types in response to any consumer CCPA request for a copy of their personal information. For example, never disclose a social security number. The AG's commentary accompanying its release of the regulations explained that this rule is intended to reduce the risk that a business will violate another privacy law, such as the California data breach law, in the course of attempting to comply with a consumer's request to know. Article 3 also details requirements around responding to consumer requests to delete. For requests to delete, the regulations are clear that if a business cannot verify the identity of the requester, the business may deny the request to delete. The business must then inform the requester that their identity cannot be verified and must treat the request as a request to opt out of the sale of personal information. This is an interesting requirement found nowhere in the CCPA that businesses should be aware of. The regulations go on to clarify what counts as a deletion. Businesses do have some options here, including permanently and completely erasing personal information from its existing systems, or the business can de-identify personal information, or the business can aggregate the personal information with other information. If you'll recall from our earlier conversation, de-identify and aggregate have a very particular meaning under the CCPA, so make sure you check that out before relying on the option to delete information through de-identifying it or aggregating it. A question that frequently comes up in the area of mandatory data deletion requirements is, does data stored in my backups count? The proposed regulations answer that question in the affirmative. Yes, backup data must be deleted. But the regulations also offer helpful clarification by providing that a business may delay deletion from its backups and archival systems. However, there's a catch. The regulations also require that the data should then be deleted when the archival or backup system is next accessed or used. Unfortunately, it's unclear what is meant by next accessed or used, but a strict reading of use might mean that this requirement is triggered each time a backup is made, which for many businesses could mean several times daily. With regard to opt-out requests, covered businesses have a maximum of 15 days from receipt of the request to act upon the consumer's request. This was a critical update on the part of the proposed regulations because the text of the CCPA is silent on how long the business has to comply with the consumer opt-out request. Also brand new is a requirement for the business to forward a consumer's opt-out requests to third parties to which the business had previously sold the consumer's personal information. The look-back period here is 90 days. So the business need not notify every single person who previously bought the consumer's information, only those third parties that bought the information from the business in the 90-day period prior to the date of the consumer's request. The business must tell third parties to stop selling the consumer's information. The business must also notify the consumer when the business has completed this process of notifying third parties that fall within that 90-day window. A reminder, as mentioned earlier, that verifying the consumer's identity is not required to honor consumer requests to opt out. However, a business may deny an opt-out request if the business has cause to believe that the request is fraudulent. The CCPA is completely silent on any specific training requirements. The regulations expand obligations in this area by requiring that all businesses must inform impacted personnel on the covered business's responsibilities. Businesses that annually handle the personal information of more than 4 million consumers must also establish, document, and comply with a training policy to ensure that all individuals responsible for handling consumer requests are informed of all the requirements in the regulations and in the CCPA. The regulations also create some new, very stringent record-keeping obligations for covered businesses. Businesses are required to maintain records of consumer requests made pursuant to the CCPA and how the business responded to said requests. And then the business must keep these records for at least 24 months. The regulations suggest maintaining the records in a ticket or log form, which includes the following fields of data, which are maintained with respect to each consumer request received: the request date, the nature of the request, the manner in which the request was made, the date of the business's response, and the basis for the denial of the request if the request is denied in whole or in part. The proposed regulations provide that the information the information maintained for this record-keeping purpose cannot by itself violate the CCPA. In other words, if a consumer makes a request to delete their information, the business's decision to retain that consumer's name solely in order to comply with this record-keeping requirement will not by itself constitute a violation of the CCPA. There's an additional requirement that information kept in the required records may not be used by the business for any purpose other than to comply with the record-keeping obligation. Some additional record-keeping and reporting obligations apply to businesses that annually handle the personal information of 4 million or more consumers. Amongst the most challenging set of provisions in the proposed regulations are those which attempt to shed light on certain matters related to service providers. To understand the issue, let's start with what the CCPA has to say about service providers. Under the CCPA, a service provider is defined to mean, basically, a for-profit entity that processes information on behalf of a business under a contract which basically heavily restricts the service provider's use of the personal information except to perform services for the business. Service provider is a critical concept in part because, remember, as I mentioned earlier, transfers of personal information by a covered business to a service provider do not count as a sale of personal information under the CCPA. Service providers can be independently liable for violations under the CCPA, and businesses are shielded from liability under the CCPA if a service provider goes off on their own and acts outside the scope of their arrangement with the business with respect to the personal information at issue. So far, so good. Then the proposed regulations come along and throw a monkey wrench into the entire operation. First is the language in the regulations providing that, to the extent that a person or entity provides services to a person or organization that is not a business, but the service provider would otherwise meet the requirements of a service provider, that person or entity shall be deemed a service provider for purposes of the CCPA and these regulations. On its face, this is a significant expansion of the CCPA's definition of a service provider, which, as discussed previously, relies on the entity to which the services are being provided being a covered business under the CCPA. So how is it now that a provider of services to an entity that is not a covered business is also a service provider for purposes of the CCPA? In its initial statement of reasons, an explanatory document released by the Attorney General alongside the proposed regulations, the AG explains that this regulation is intended to ensure that service providers to nonprofits or governmental entities are still covered as service providers by the CCPA, even though nonprofits and governmental entities themselves are excluded from the CCPA's definition of a business. Without this clarification, the Attorney General is concerned that entities that process personal information on behalf of nonprofits and governmental entities in accordance with a written contract may be required to comply with consumer requests, even when those nonprofits and government entities in ultimate control of the information are not required to do so. However well-intentioned the AG's regulation may be, one could argue that this expanded concept of a service provider exceeds the scope of the Attorney General's rulemaking authority. Worse, the proposed regulation does not even mention nonprofits and governmental entities, so theoretically, it extends the service provider label to more vendors than simply those that service nonprofits and governmental entities. Moving on, the regulations provide that service providers should not use personal information received as a service provider to provide services to another person or entity. The only exception here is if it is necessary to detect data security incidents or protect against fraudulent or illegal activity. The regulations also create a new obligation for service providers that if a service provider receives a request to know or a request to delete from a consumer, and the service provider does not comply with the consumer's request, The service provider is required to explain to the consumer the basis for the denial. The service provider also must inform the consumer that it should submit the request directly to the business on whose behalf the service provider is processing the information. And when feasible, the service provider is also required to provide the consumer with contact information for that business. Finally, the regulations recognize that a service provider can be both a service provider and a covered business at the same time. So, service providers must comply with all requirements under the CCPA that apply to its activities, both as a service provider and as a covered business, when and as appropriate. Next, we turn to the final segment of this presentation, in which I wanted to run you through a few practical, actionable items for you to complete as you go about applying the CCPA to your business. To be clear, this list does not represent an exhaustive list of things to do to prepare for compliance, though I've tried to touch on all the major categories. The first couple items, I suggest you try to perform in that order. The remaining items are entirely up to you. You decide the order in which you'll take these on. But I just wanted to give you a rough idea of the work that lies ahead. And if you're covered by the CCPA and have not yet begun to set up a framework for compliance within your organization, here are some items that you can begin with. So the very first thing to do is to assess whether the CCPA applies to your business or if an exception applies. This is going to mean take a look at that definition of business. Do you qualify? This is going to mean take a look at that definition of personal information. Do you actually handle personal information? If it turns out you are covered by this law, the next thing you should think about doing is to implement reasonable security procedures and practices appropriate to the nature of personal information your business possesses, and as soon as humanly possible. Remember that private right of action? You can bet your bottom dollar that plaintiffs' lawyers are getting everything ready right now to begin taking advantage of the CCPA's private right of action for data breaches. Businesses need to be ready to protect themselves against these lawsuits, and the best way to protect yourself is to implement a documented information security program within your organization. If you already have one, great, but if not, now is your opportunity to implement one. Next on the list, determine whether your business will extend CCPA rights to all individuals or to California residents only. As you evaluate your options here, ask yourself, do you have the capacity to distinguish between information from California consumers in your database from information belonging to others? Next on the list, create a data map. This process involves creating a guide of sorts to where and how you keep and use personal information throughout your organization. A data map should be able to answer the following questions. What personal information is your business in possession of? Who do you share it with? And from what sources do you receive personal information? Next on the list, remember to create processes for consumers to exercise their right to know. Remember that an 800 number is always required. And an interactive web form is also always required if your business has a website. Also on my list is to create a process for consumers to exercise their right to delete. And in connection with the law's opt-out requirements, you must further remember to set up that little do not sell my personal information or do not sell my info link on your website's homepage. Next up, select the compliant process for verifying the identity of California consumers. Remember that this can be achieved through retaining a third-party identity verification service provider to fulfill this function on your behalf. Also remember to review and update your privacy policy and website notices. Remember that the CCPA has some special form and content requirements related to privacy policies, so your old privacy policy almost certainly does not fit the bill. Next, remember to establish a record-keeping process. An additional item you may need to address is to update your contracts with covered businesses, service providers, and third parties. Include contractual provisions adequately defining use of personal information. Remember that a service provider is not a service provider without the appropriate contract language being in place. And if you are the service provider, ensure that contracts you're being asked to sign are not so restrictive that you cannot comply with your own obligations under the CCPA. Service providers might also want to ensure that the service provider's obligations in contracts with covered businesses do not impact data held by the service provider that were not obtained by the service provider while providing services to that business. Last on my list is an item that should be relatively easy for all but the largest handlers of consumer personal information to comply with, and that's the requirement to establish a compliant training process. That's all I have for you today. Please note, after this presentation, we'll be emailing everyone a copy of the slides used in this presentation. Thanks again for joining me. I hope you found this presentation to be useful, and I wish you the best as you go about finalizing your plans for compliance with this hefty and challenging piece of legislation. If you have any questions on the CCPA and how it might apply to your company, or how it may affect your business model, please do not hesitate to reach out, and I and my esteemed colleagues in the Technology and Data Privacy Practice Group here at Bayer Crossing McDemus will be very happy to sit down with you to help you work through whatever challenges you may be facing. Last but not least, before I go, please accept my warmest wishes and the very best to you in the holiday season ahead.